Hello, Environmental Policy 1 students. Dr. Conway here, back for Lesson 6 on legal context, federalism, environmental policy. It's important also to see this lesson as part of that narrative that we've been running in the course, right? Where we've had different conceptions of economics and environmental economics, different conceptions of the integration of environment and economy, right? Then we moved a little bit into some of the principles of environmental law that we try to get moved into legal infrastructure so that the environment can be further taken into account in economic decision making and in government decision making. And now we're moving into sort of the context, the more structural or institutional context of law and federalism and how environmental policy must operate within those constraints as well. Okay, and remember, the whole concept of ideational or major paradigms of society, major process and institutional or structural considerations in society, which all shape, right, environmental policy, how it might be made, must be made, and what barriers must be faced when you're trying to advance environmental policy, because all of these ideas, processes, and institution structures, they have a historical legacy behind them. They have their own momentum, right? And they're the context within which we have to operate as a result, correct? You can't just wish them away, you have to work with them. And so it's important for environmental policy students to understand these dynamics. All right, so let's get started on this, okay? Now, let's deal with some of the legal infrastructure that we have to operate in. Before, you learned about principles and what constitutes the components of a legislative act. But now we're pulling ourselves back and looking at law from the perspective of structures. And a major aspect of that in the Canadian context, of course, is federalism. But let's deal with some of the legal structures first, okay, that we have to deal with when we're trying to become knowledgeable about environmental policy. Okay, let's start with some basic understandings, right? We all know that in liberal democratic countries, legal infrastructure applicable to environmental regulation, and I mean regulation in the broad sense, not a particular policy instrument, but regulating the quality of the environment, is comprised of the Constitution, legislative acts, and laws of general application to all other legal instruments. If you're not really detailed or not, really immersed in this material, a lot of books will not talk about laws of general application, but they are critically important to how all policy measures are developed and implemented. Okay, so I'm going to introduce you to those issues, which is another layer of legal infrastructure. Okay, now a constitution, we all know, is the preeminent law of a political system. Okay, it typically consists of rules governing the relationship between citizens in the state and between different parts of the state when you're dealing with a federal state, which Canada is. When you're dealing with a unitary state, the Constitution might address other aspects of division of powers between legal entities or state components. But in our case, the major division of power occurs between the federal government and the provincial government. And in that context, it's very important for students to understand that the provinces are not the children of the federal government, right? The provinces have their own constitutional powers, okay? And the federal government has its constitutional powers. The municipalities are the children of provinces, but the provinces are not the children of the federal government, all right? So that's very important to understand, and the Constitution is very clear on this matter, right? The Canadian Constitution was patriated from Great Britain in 1982. It consists of written documents, court decisions, and unwritten conventions. Most people don't realize that. They might think the Constitution is just a piece of paper. It is not. Okay, it does have written documents, obviously, right? Including the Charter of Rights and Freedoms, which defines the limits of the state's power over the individual. All right, but it also includes unwritten, court decisions. When the Supreme Court makes a decision about something, that becomes part of the constitutional matrix that we have in the country, right? It becomes part of supreme law. Because once the Constitution decides, there's no higher court. I mean, in the political sense, there's no higher court, right? There might be in the moral and ethical sense, but in the political sense, in the legal sense, in terms of the legal infrastructure, there is not, right? So it becomes part of the matrix of constitutional law within the country. right? And then there are unwritten conventions, right? Informal and uncodified procedural agreements that are followed by state institutions. Okay, and these become part of law because if a dispute goes to the Supreme Court will say, look, we've always done it this way, and once the Supreme Court makes a decision in that context, this becomes a common understanding and part of the constitutional matrix. Okay. So together these constitutional components describe the basis and method by which political representatives are chosen, how that we must run elections in certain periods of time and they must be run in a certain way, okay? The scope for legitimate state power, including how it is limited, i.e. vis-a-vis citizen rights, collective or individual rights, okay? Charter of Rights and Freedoms. And there's a difference between collective and individual rights that if you want to get into it more of the political science focus, I would often spend a whole class, a lesson just on that aspect, but we don't need to go into that detail in this context. And then division of powers in the Canadian Federation, which is a key issue for environmental policymakers in Canada, obviously, right? So now, the federal division of powers in a federal system of government, the constitutional authority to make laws and to tax is divided among these different levels of government, right? We know that, right? In some cases, such as with respect to responsibility for the environment, however, the constitutional division of powers is not clear. It is not mentioned in the Canadian Constitution, right? So governments get at the environmental issue from other powers, indirect powers, like the federal spending power, the federal power for international relations and transboundary issues, right? The provinces get at it from the perspective of natural resources, industry and commerce, these kinds of things. All right, so that creates fertile ground, obviously, for quite a lot of moving and throwing, right, maneuvering and political conflict. Okay, and because of that, constitutional federalism is always in flux. It is never fixed in stone. All right, so that's the dynamic that environmental policy must operate in a Canadian context, okay? And it also, federalism also requires us then to establish quite an elaborate set of institutions and processes through which political and policy decisions are made and implemented, okay? First ministers, the prime minister and premiers all meet periodically to address national issues of highest importance that transcends single ministerial mandates. But there's also meetings of ministers of the environment, and there's meetings of ministers of health. Right? This has to be institutionalized. But when you're developing policy instruments, there's also thousands of informal relationships between levels of government, like a regulator in the federal government looking at banning single-use plastics. That doesn't move forward without substantial informal or consultation on that issue at the regulatory official level between all of the governments, right? Because that's the way federalism has to work. If it doesn't work that way, then you get blow-ups in the media, right? Like we're getting between Alberta and Saskatchewan and the federal government with respect to the carbon tax. Sometimes those blow-ups are absolutely going to be necessary, right? Because they're not resolvable in normal processes or in current federal provincial institutional mechanisms, so they have to be pushed up to the courts to find a resolution, okay? And that's okay. That's why the courts are there. That's why the system is set up to enable that kind of dispute resolution, all right? And there are numerous formal standing administrative bodies, such as the Canadian Council of Ministers of the Environment, as I said, CCME, all right? But on that's fine. But there's also, you have to realize that, there's a complex policy environment also within the branches of government itself, each individual government. For example, at the federal level, there's the executive branch, we know that, right? There's a prime minister and the cabinet. There's a legislative branch, the Senate and the House of Commons. And there's the judicial branch, the courts, and especially the Supreme Court, all right? This is often called the machinery of government. Why do we are concerned about environmental policy? Because to get environmental policies approved in terms of legislation or policy instruments, this is the maze that we have to travel through. And this doesn't even yet talk about the interdepartmental. Each department and agency has its own mandate embodied in legislation that they have a responsibility for. So departments negotiate on an ongoing basis as well, right? So at the same time that you want to advance something in an environmental policy instrument, you have to deal with federal provincial dynamics. But before you even get to that stage, you're dealing with interdepartmental dynamics within the governments themselves. Remember, right? We're dealing with the dominant paradigm in that context as well, right? The dominant economic paradigm, right? The pressures to talk about growth, the pressures to talk about all these things that we've been talking about through the first 4 or 5 weeks of the course. Now, I don't want to get into this stuff very much, but you should know about it. The executive branch is the decision-making arm of government, obviously. Primarily the executive branch, it's the Prime Minister's office and the Cabinet, will advance bills for legislative consideration. And they will direct and oversee day-to-day operations of the administrative arm of the government, or the bureaucracy. Because a minister will be appointed to be Minister of Health or Environment, and they're responsible for that administrative arm of the government, okay? A bill is proposed to the legislative branch for a new legislative act or a proposal to change an existing legislative act. Now, that's typically done by the executive branch, right? But private member bills do occur. They don't go very far usually. They have, but they normally don't. Most of the bills that actually get passed by Parliament are those proposed by Cabinet, okay? So when adopted by legislative branch, bills become legislative acts constituting a portion of the country's law, right? This, I'm saying it in 2 minutes, something that can take 2, 3 years, 4 years for a piece of legislation to pass, right? Now, regulations and other policy instruments, are developed under the authority of legislative acts. That's why you need to know about legislative acts, because if you're trying to advance an environmental policy instrument, an environmental policy that requires regulation or an economic instrument or some other action, those can only be adopted under the pre-existing powers of a legislative act, right? So legislative act are enabling legislation. They set out the issue and objective, as you're learning from your assignment for week 5. They set out all of these things, right? And the department is responsible. Department or departments are responsible for implementing this act. And the way they can implement this act is by developing policy instruments, which are the tools for implementation of an act. But those policy instruments must derive their legal authority from the provisions of the legislative act, okay? And administrative departments and agencies have mandates to develop these policy instruments on behalf of the minister, right? And I'll talk about that in a minute when I talk about laws of general application. To manage all this diversity of all the departments and agencies in government, there are central agencies that are really critical for any policy person to understand. These central agencies will occur at the federal level, but similar entities will occur at the provincial level as well. Okay, that being the Prime Minister's office, the Privy Council office, the Treasury Board Secretariat, and the Department of Finance are central agencies, and they're responsible, obviously, Department of Finance, for overseeing the financial accountability government-wide. Treasury Board of Canada Secretariat, budgeting and developing regulations or policy instruments across government are coordinated according to cabinet directives by the Treasury Board civil servants, okay? The Privy Council office, which serves a role in approvals and feeding things to cabinet, and the Prime Minister's obviously services the Prime Minister and his or her immediate cabinet, okay? The central agency monikers applied to designated organizations that have that central coordinating function. So if you're sitting in Environment Canada or Health Canada, you're advancing an environmental initiative, you have to deal with these central agencies, and you will have to deal with departments that have mandates that are impacted by your proposal for action, okay? All of that in addition to having to deal with the federal provincial dynamic, okay? The Treasury Board of Canada Secretariat oversees coordination to regulatory policy standards of all regulations developed in the federal government, okay? The judicial, they don't do the work on the regulations. The specialty department does, right? Environment Canada, Health Canada, Agriculture Canada, whatever the case may be. But they coordinate the process that all regulations have to go through to get to cabinet approval, all right? The judicial branch is primarily involved in resolving disputes in the implementations of laws and regulations, as I said, with respect to the Supreme Court. In other words, in summary, there's a dynamic and important relationship among the branches of government. One department can't just develop a regulation or a policy instrument that can affect the other mandates of the government without consulting with those organizations. And that will be coordinated by rules established by these central agencies. Okay? And then once a government starts to move towards approving a policy, then negotiations will also be occurring in parallel in part, but maybe a bit later in the cycle between federal and provincial governments. Okay, so this dynamic must be well understood. Now, in addition to these kinds of things, the Constitution and the Legislative Act, which is necessary to outline the powers that any future policy instrument, a regulation, an economic instrument, any other thing, must derive its power from that legislative act, right? But in addition to that, we have what's called laws of general application in the government that impact every policy instrument produced by the government, okay? They apply to regulation, design, and implementation, or of any policy instrument design and implementation, because the courts presume that they apply except when some other act says otherwise. They support values found in Canadian society, and regulators can rely on the solutions that these laws provide instead of having to develop their own solution in terms of due process. Okay? So that's the way the courts interpret laws of general application. Okay? But what are these laws? Okay? Well, the first very important one is the criminal code. Okay? Because when you apply laws, even tertiary laws like regulation, economic instruments, permitting and licensing processes, all of these things, they all are imposing legal penalty when something is not followed, right? And the criminal code is not only about criminal offenses the way we think about it when we're watching Law and Order on TV, but also addresses rules of procedure for investigation, warrants, and conducting trials more broadly, all right? So, how information must be collected, how it must be tagged, how it must be stored, all of that applies to an environmental enforcement officer just as it does to a detective in the Ottawa Police Force, all right? So the Interpretation Act for the Criminal Code stipulates that the legal rules of procedure must apply to offenses created by any federal act or regulation. Okay? So, that means that the criminal code is directly applicable to all of the policy instruments that we would typically develop, except for voluntary suasion and those things. But anything that can include legal sanction must conform with due process under the criminal code. Okay? The next one is the Financial Administration Act, also really critical to any environmental policy measures, okay? This act provides the legal basis for the government's financial management accountability. It establishes two departments, Department of Finance and Treasury Board. Regulations or other policy instruments should not duplicate the provisions of this act with respect to how it authorizes fees to be prescribed for government services or facilities. In other words, licensing, fines, all of those things, if they're set up in an environmental policy instrument, must comply with the Financial Administration Act. Now, the reason we have these laws of general application is that all of this stuff that's in all of these laws of general application acts don't have to be put into the policy instrument document every time, because the courts and government officials will assume already that they apply, right? And that's why we call them laws of general application, okay? Another one is the Interpretation Act. The Interpretation Act prevents the repetition of rules that apply broadly in every act and regulation. The Act stipulates two especially important powers from a regulator's perspective, okay? The power of the departmental officials to exercise on behalf of the minister presiding over that department, powers conferred by law on that minister. In other words, the minister of the environment doesn't develop the details of a single-use plastics ban, right? But the minister delegates that to their officials under the power of the Interpretation Act. He or she delegates it to the experts in the department to do that, right? Ministers don't develop these instruments, right? Ministers direct that they be developed under the authority of a legislative act by the experts that have been hired within their departments, okay? The power of regulation making authorities to amend or repeal the regulations, right? So in other words, the officials also have those powers to suggest regulation amendments or refinements or new regulations be developed, as long as what they're proposing is consistent with a legislative act, the powers allowed in a legislative act, or the authorities as we call it, and that their minister is a designated principal authority for that act, okay? Another one is the Privacy Act, right? This is really important to environmental reporting, for example, okay? The Act protects the privacies of individuals, including corporate entities, with respect to personal information about themselves held by federal government institutions. It also provides these entities with a right of access to that information. So this is why you'll often see environmental policy instruments that call for reporting also declare confidentiality requirements, right? Not releasing commercial information from one entity to another, right? It's confidential information. The Privacy Act is very strict and applies to all policy instruments. Then there's the Statutory Instruments Act, okay? This act provides for the examination, registration, publication, and parliamentary scrutiny of policy instruments. In other words, this is how the Statutory Instruments Act defines policy instruments and defines how in the process of government they must be developed, okay? So the government makes regulations public via registration with the clerk of the Privy Council and publishing in Canada Gazette as one example. But there are a number of provisions of what a policy instrument must go through under the authority of a legislative act to get cabinet approval. It's a very important. If you're working in any kind of policy development in government, you know the processes that are required, and you will know the Statutory Instruments Act. Okay. So these are very important contextual things, but the biggest one that we see a lot in the press and so on with making environmental policy is, of course, the scope of environmental laws in the Canadian Federation, in Canadian federalism, right? And we have discussed federalism in the context of structural and institutional constraints earlier on, right? But we want to step further to develop a better understanding of how federalism influences the scope and technical and political complexity of environmental policy, legislation, and regulation in Canada. All levels of government across Canada enact legislation to protect the environment, right? I mean, the provinces have their own environmental policies, and the federal government has theirs. Some municipalities even have their own, right? So that at every level of government, there's activity going on in the environment, which creates an interesting dynamic in terms of coordination, not overlapping, right? And of integrating these efforts, okay? And this includes federal, provincial, territorial, and municipal governments. As I said, there's scarcely a single environmental policy in Canada that is not impacted by this diversity. All right, and so good environmental policy people need to be, if you're, say, specializing in the regulation of plastics, you need to know what the municipalities are doing, the provinces are doing, the federal government are doing, and then we lecture next week what's going on internationally, whether you're transgressing any international agreements or what might be going on. So you can understand, right, the structural context within what you must operate. All right. Now, the federal government continues to have an active role to protect the environment from its jurisdictions, right? That are not set out in the Constitution, as I said, but from its jurisdictions over transboundary issues, protecting water frequented by fish, international treaties, and other areas. So they use those powers from the Constitution, again, those authorities from the Constitution, to leverage in to environmental work, to develop legislative acts which would then empower policy instruments, all right? Provinces have always played a central role because of their jurisdiction over natural resources is a key one, obviously, okay? But more recently, municipalities have gotten involved primarily in cases of toxic waste, right? Contaminated lands, liquid effluent discharge, reporting on the emission of chemical substances. You know, the bigger municipalities like Toronto, Vancouver, Ottawa, municipalities like that have their own environment departments that are also active in this area, right? So you begin to get a sense as to the sheer size of the matrix that you've got to operate with when you're trying to advance environmental policy in a complex, developed country that is as big as Canada is, okay? And it has a federal constitution. So one of the key questions for environmental policy students is whether this proliferation is good for environmental policy or is bad. There's a debate out there, that competitive federalism is in fact good for environmental policy. So I don't want to turn it towards, oh, this is so difficult, it's so bad, it's so hard to navigate all this. Yeah, it's difficult to navigate all this because environment economy integration is a very complex and multifaceted issue. But there are some out there that argue that competitive federalism, competition between the federal and provincial governments, advances better environmental policy. Others would argue that these become structural barriers. That means that we can rarely act as fast as we need to. We're not going to go down that road now, but it's something certainly to think about, right? And to add to this federal-provincial complexity, of course, is the courts, right? The courts have been very active in interpreting environmental jurisdiction, the legality of policy instruments. We have before the Supreme Court right now the question of the legality of the carbon tax, right? Standards and principles for enforcing environmental legislation. So the courts are also very active, okay? And they can validate or invalidate current laws, okay? And now there's a whole new dynamic that we're seeing, right? Over things like, pesticides and other glyphosate and that Roundup case and a few other cases, many other cases actually, where civil environmental lawsuits are beginning to impact environmental policy, right? Civil environmental lawsuits over, toxic chemicals and contaminated land, noxious air emissions, noise in major industrial projects. Now we have, NGOs being very active in taking civil cases to the courts, okay? And we also have cases of liability and large awards being awarded to harmed people according to the courts and so on, right? So we have that whole additional layer also, right, which can be very advantageous for promoting and pushing the environmental agenda, right? But it also adds uncertainty when you're trying to roll forward with a policy instrument, right? Ministers don't like to release a policy instrument and start working on and implementing it, and all of a sudden it faces 30 civil lawsuits. It's a dynamic that's quite interesting to see from inside the system. Trust me. Okay. In addition to law and policy instrument fragmentation with all these dynamics, much of the environmental policy friction we see between levels of government can be tied back to some fundamentals that we'll never be able to eliminate, though, right? I mean, these are some realities of a country that is big as Canada and as diverse as Canada, right? The diversity of Canada's geophysical characteristics alone dictates difficulty in coming up with environmental solutions, right? We have, the Rocky Mountains in BC all the way to the flatlands of PEI. We have the prairies in the central west all the way to the Great Lake regions in Ontario and Quebec. All of these geophysical properties creating different economic priorities, right? Some are mining, some are forestry, some are manufacturing, some are using water, some aren't. So you can imagine, right? And all that geophysical variety also kicks up a lot of economic diversity. We have Alberta and Saskatchewan heavily dependent on oil and gas. We have BC dependent on fisheries, forestry, and now modernization with high tech and medical research and other things like that. We have Ontario, major industrial base, but also has mining, has to deal with the Great Lakes, has inland fishery. We have Quebec, same sort of profile as Ontario, right? Although different cultural dynamic, and we're not even talking about that. And then you have the East Coast. I mean, you can see the relative, the actually quite considerable differences of geophysical properties of each province and economic profile of each province as a result. So this is a very difficult dynamic to have to manage, right? When you're trying to respond to an environmental problem. We're trying to impose a carbon tax to deal with GHG emissions. Well, obviously Alberta and Saskatchewan are going to feel like that's a 2x4 right between the eyes because they have so much geophysical and economic characteristic tied up in oil and gas, right? So, we can get annoyed that they push back on environmental measures, but it's a difficult situation, right? It's not something that we can just kind of say, oh, they're just a bunch of rednecks or what. No, they're not, right? We think that they can do things to mitigate these problems, and they can, but, it's a lot easier said than done when you've got a large constituency and you're sitting in Alberta and you're the premier and you've got lots of lobby groups pressuring you to defend oil and gas. It's a difficult proposition. It's not easy, all right? So together, these factors create substantial divergence of perspectives on environmental protection priorities, all right? Now, that's a key message I wanted to get across. Now, what we have in the rest of the slides are just some of the examples of the various legislation that has had to move through this dynamic, and all the policy instruments that have been developed under these legislative acts that have moved through this dynamic, all right? And you can see the diversity of what we're talking about here and what the landscape is in this structural context, okay? We've got all of the federal acts, right? We've got, these. I'll let you go through these. I'm not going to spend a lot of time on these, but you see the major federal environmental laws. But we also have all the provincial environmental laws that mirror, in many ways, the federal environmental laws, okay? Now, you have these slides, so I'm not going to talk through all of these, but you get the context of what I'm talking about here. Now, I don't want this to come across as a fatalist message, right? This is just a message of reality, of what we're dealing with when we're dealing with a complex, huge, geographically speaking, country like Canada with so much geophysical and economic diversity, and within the government structures we have within a federal system. It's moving an environmental policy is quite an exercise, right? So people can sit back and be extremely frustrated that action isn't happening faster, and I would be one of those. It's incumbent upon us as environmental policy people to make it a less emotional exercise and instead make it an exercise that understands the dynamics that we have to, the structural, institutional, and ideational dynamics that we have to deal with, right, in moving environmental policy forward, all right? So on that score, I'll let you go, and I'll see you next time. Bye-bye now.